Benedetto, good afternoon. You can go ahead and come forward, please. And Ms. Benedetto, I'm going to go ahead and have you have a seat right there. Please make sure the microphone is in front of you and the green light should be on. That's really important so that we can make sure that everything that we are discussing here today gets picked up.
Can you hear me?
Yeah. Yep, I sure can. Okay, so we are before the court for a special set 2 o'clock calendar in City of Lakewood versus Gail Ann Benedetto. 2 different cases involving Ms. Benedetto, 25L000583 and 25L004426. Both matters are before the court today for pretrial conferences. By way of procedural history, Ms. Benedetto was last before the court, let's see here, back on September 9th, 2025. At that point in time, Ms. Benedetto made a motion to the court to have her attorney of record from the Horwath law offices, and I believe, if I remember correctly, that was Ms. Arnold, although it was Ms. Capone that was present at that time with Ms. Benedetto. Ms. Benedetto made a motion to assert her constitutional right to represent herself and to proceed pro se. The court reviewed the waiver of attorney with Ms. Benedetto on the record, and the court was satisfied that Ms. Benedetto understood the potential risks that she was taking by exercising that right. Nevertheless, Ms. Benedetto maintained her request to proceed with representing herself, and the court granted her request to do so. Ms. Benedetto then, towards the end of the hearing, and that was on a regular pretrial conference calendar where a number of other matters were waiting, Ms. Benedetto made a further record that while she wanted to represent herself, she wanted to have standby counsel appointed to represent her. At that point in time, Ms. Capone, I don't know what her terminology was, but she essentially chose not to make a record, is my recollection. I could be wrong, but I believe that's accurate.
All right, guys, buckle up, because today we got a full-blown Karen moment straight out of Courtroom. This isn't your usual drama. This woman, Gail Ann Benedetto, decides she's too smart for lawyers and insists on representing herself. That's right, no attorney, just pure Karen energy. But wait, she doesn't want to go fully solo. She demands someone hold her hand as standby counsel. Already sounds messy, right? Trust me, it gets even wilder. 041 to 125. Before we dive in, let's rewind. Last time she was in court, Benedetto ditched her actual lawyer.
Mr. Graham put the court on notice that the prosecution may very well object to, I believe, what he was concerned might constitute hybrid representation under Washington law. And Ms. Benedetto, we set the matter over to today so that I can ask Ms. Arnold and Ms. Capone's supervisor, Angela Horwath, who is the lead attorney at that firm, to be present because they were previously your attorney of record and would be the court's default choice for standby counsel if the court appoints standby counsel. And I also wanted to give Mr. Graham an opportunity to further elaborate on any concerns he had as the prosecutor. Again, the reason I didn't do that at the last hearing were time constraints. The issue that was scheduled to be addressed by the court today was a fairly limited one. I wanted to make sure that Ms. Benedetto, after having some time and opportunity to review the waiver of attorney, was still wanting to proceed pro se and represent herself, as she previously indicated. If the answer to that question is yes, then I wanted to next ask her whether or not she is continuing to request that standby counsel be appointed. And then at that point, if she is indicating that she is, I want to give Mr. Graham and Ms. Horwath an opportunity to weigh in as well. So first things first, Ms. Benedetto, good afternoon.
Good afternoon, Your Honor.
So Ms. Benedetto, at our last hearing, we started off kind of rocky, but by the end of the hearing, I think we were doing pretty well. I'm going to remind you that I'm going to do everything I can not to interrupt you, and I'm going to ask that you extend the same courtesy to the court as well as the attorneys, okay?
Yes, sir.
I'm also going to remind you that everything is being recorded today, so this is all on the record, if you will. So, Ms. Benedetto, your true name is Gail Ann Benedetto, correct?
Yes.
Okay, and Ms. Benedetto, you had previously indicated to the court you wanted to represent yourself. Have you had any change of heart, or is that still how you'd like to proceed?
Claiming her constitutional right to be her own attorney, the judge warned her, flat out, that it's risky business to play lawyer without a degree. But Karen wasn't having it. She said, "Nope, I'll represent myself." The court reluctantly agreed, but things didn't stop there. At the end of that hearing, she suddenly demanded a standby lawyer too. 126 to 205. Now here's where the chaos begins. The prosecutor smelled trouble right away, worried this would turn into hybrid representation.
I question how we can proceed because I just feel like I think the term is fatal defects in the process, such as the 48 hours to have the procedural due process, right? Which I was basically forced to push through. So I was denied the right to question the arresting officers as to their training or what exactly did Mr. Graham, under a penalty of perjury, say that he feels he has sufficient evidence beyond a reasonable doubt that I've done these things that I'm not guilty of. And in all actuality, I was the actual victim on both of those occasions. And I would ask the court to investigate the address because I'm not the first one. I know of at least another woman before me. Her name was Stephanie. I don't remember her last name, but it's a pattern, and I don't know how deep it goes. But I just want to also put the court on notice that
Basically, Karen try and control the show while still blaming the lawyer when things crash and burn. The judge put the brakes on, rescheduled the hearing, and called in backup. He wanted Benedetto's old firm present, plus the head attorney herself, just to decide if anyone should babysit Karen while she practices law in her own case. 206 to 245. So today's hearing kicks off. The judge, calm and professional, remind her everything is recorded. He asked the simplest question.
I've already been violated by my country to the betrayal of giving your citizens that you don't have any business arresting, putting them in a tribal jail that's 98% American is not tribal. It's money laundering or whatever you guys want to call it. It's fraud, and you just push everybody through. The fact that two different lawyers gave me the same script both times shows that that's your process and procedure, is to habitually and continuously deprive these people of their rights. And then for Nisqually to make me leave in 46 degrees raining weather on March 20th with no shoes, nothing but a small dress. I had no wallet, no phone, no nothing. I was passed out in my Jeep, completely unconscious when the police officers arrived. They didn't witness me doing anything malicious, and I did not do anything malicious. I had no malicious intent, and you will not be able to prove that beyond a reasonable doubt. So for him to lie and say that he has it, and for you to just continuously sign off. And also, I've discovered that a police officer, when he enters the charge with his badge number, automatically signs your auto signature to the warrant, so you don't have any knowledge of the warrant. That an officer is not a judge.
Do you still want to represent yourself? You'd think this was a yes or no question, right? But no. Karen launches into a full rant, dodging the answer. She accuses the system of fatal defects, claims her rights are violated, and says cops lied under oath. Folks, she's not answering the question. She's running her own conspiracy seminar. 246 to 330. And let's be real here. She's not just complaining. She's throwing everything at the wall. Due process violations, fraud, secret money laundering.
So, Ms. Benedetto, The issues that I just heard you describing, what you've raised is a number of issues that would be
And there's,
motions, hold on, motions to dismiss this case. Hold on, I let you finish, now you let me finish, okay?
yes, sir.
I'm not contesting that. I think you do have the right to bring whatever motions that you think are appropriate if you believe your rights were violated. My question for you at this point is, people in criminal cases in this state, in this country, bring motions to dismiss every day. The question that I need you to answer for me is whether or not you want to be assisted by, for being represented by an attorney when you bring those motions or when you seek that relief, or is that something that you want to do representing yourself? Previously, last time we were here, you said, no, Judge, I want to represent myself. So is that still the case, or are you now thinking that you want to be represented by an attorney?
I mean, if you have a competent attorney who is going to do their job like they took an affirmation to do, not Horvath or however you pronounce it, obviously her law firm has failed me twice, so I shouldn't be obligated, and I'm not obligated to accept any representation, especially from people that don't represent anybody but themselves.
So remember that, well, I shouldn't say remember. So under Washington law, if you qualify for representation at public expense, you don't get to choose your lawyer.
Even weather conditions the day she got arrested. I mean, seriously. She's claiming she was left outside in freezing rain with no shoes and that the police pushed her through a corrupt system. Instead of focusing on the charges, she paints herself as the ultimate victim in some grand government conspiracy. 331 to 410. The judge tries to stay cool. He explains that motions like hers, claims of rights violations or wrongful arrest, are normal in criminal cases. People file them every day. But he circles back to the real question. Do you want a lawyer or not?
Right.
Now, I have appointed an attorney to represent you previously. You indicated that you did not care for that representation and that you wanted to represent yourself. The other option that you have is to hire your own attorney, and you do have a choice when you hire your own attorney who you hire to represent you, but you obviously have to have the means to hire an attorney. So I can give you time to try and hire an attorney if that's what you want to do, or you can proceed with representing yourself, or you can be represented by a court-appointed attorney, assuming you continue to qualify, but you don't get to pick that attorney, right? The attorney, that attorney is picked by the court. So you may not like the choice, but that would be how that process would work. So knowing those three options, you can either hire an attorney, you can represent yourself, or you can take a lawyer that I appoint to represent you. Do you know how you want to go forward?
I have looked into different avenues, and nobody has so far wanted to, I guess, take on the case.
And guess what? Karen keeps spiraling. She says she'll only take a lawyer if it's someone she approves of, not public pretenders who, in her words, don't represent anybody but themselves. 411 to 455. Now, the judge has to lay it out. In Washington, you don't get to pick your free lawyer. You either hire one with your own money, except the court-appointed attorney, or go full pro SE simple choices. But Karen doesn't like any of those. She claims she's already tried other attorneys, and none of them wanted her case. Gee, wonder why. Maybe because her defense sounds like a Facebook rant more than a legal strategy. 456 to 535.
I need at least 14 court days, I believe, per the rules to actually file the motions. So I wasn't even given enough time, which is why I brought them, because it said that if I didn't file it in the right amount of time, I could submit it for you to, I forget the word, but basically to go over a review in court. But I probably don't have the whole thing exactly perfect, how it's supposed to be heading-wise and stuff like that. So I do need more time to prepare proper, I guess, notices or motions, although I don't feel comfortable moving anything, because I don't think that anything has, can move. I mean, like, literally have probably 10 or 20 violations that I can just name them, that you guys, your own rules that were not followed. So how can you, in your official capacity, knowing your oath and knowing the Constitution, right? How can you proceed like, just like, what's Washington Constitution, Section 1? What is that? Do you know that?
Are you-
Washington State Constitution, Section 1, you know?
So, Ms. Benedetto, I think I understand the point you're making. I mean, what you said is you don't believe that the rules have been complied with and that your rights have been violated. I understand that.
Well, not just my rights, but like.
Right, I get that.
RCW 1031-100, unlawful warrantless arrests.
She then demands more time to file her motions, whining about 14 court days and unfinished paperwork. And when I say demands, I mean full Karen mode, arguing about every little detail. The judge tries to move forward, but she keeps derailing, tossing out accusations that 10 to 20 violations have already happened. At this point, it's less of a hearing and more of a one-woman conspiracy lecture. The patience in that courtroom must be legendary. 5:36 to 6:15. Then comes a cherry on top. Karen says she doesn't even have a valid Washington driver's license and accuses the court of fraudulently making one for her. Yes, you heard that right. She insists she's a Pennsylvania Dutch resident and compares herself to a pilgrim betrayed by the Indians. Folks, the judge is just sitting there trying to figure out, is she serious or is this performance art? Either way, the nonsense keeps piling higher. 6:16 to 6:55. Finally, after nearly 12 minutes of sidestepping, accusations, and constitutional lectures, the judge drags her back to the original question. Does she want standby counsel? She reluctantly says yes. But here's the kicker. She clearly doesn't understand what that means. Standby counsel won't fight her case, won't build her defense, and definitely won't risk their license for her wild theories. They're only there to explain rules. Translation: she's still on her own.